Hello, welcome to this edition of the Lexbe eDiscovery webinar series. My name is Christian. I'll be presenting our speaker and our topic today, which is the Litigator's Guide to Negotiating eDiscovery Requirements. A little bit about the eDiscovery webinar series. It takes place monthly, covers a variety of relevant eDiscovery topics. And if you have technical issues or questions during the webinar, please email webinars@lexbe.com. A little about Lexbe here. We're an Austin, Texas-based eDiscovery software and services provider. We specialize in working with small and medium-sized firms on larger cases. And here you see a little bit about Lexbe on these 3 bullet points and some reviews. After the webinar, there will be downloadable resources available. The webinar is available for viewing as a streaming on-demand video. The PDF presentation, the slides will be a PDF presentation that can be downloaded. There's an MP3 podcast. And you can also follow us on LinkedIn for notices of future webinars. A little about our speaker today, Gene Albert. He's the CEO of Lexbe. He's a frequent speaker and author on eDiscovery and legal technology issues, a member of the Planning Committee, Electronic Discovery Institute, State Bar of Texas. He's an eDiscovery consultant and expert, and he has his MBA from the University of Texas and JD from Southern Methodist University. And with that, I'll turn things over to Gene.
Thanks, Christian, and thanks everybody for attending today. I'm excited about doing this webinar. We've been wanting to do this for a long time, and I'm happy we've finally gotten around to it. It's a really important topic, and we find it's increasingly important with our clients. The agenda of what we'll be doing today will be go over what are ESI agreements, orders, protocols, etc. Why are they becoming more important? What are the underlying legal requirements? And then we'll get into the particular points for inclusion in orders and agreements, and go into detail of what are in these things and why. And then at the end, I want to make reference to that we're going to provide a reference guide of eDiscovery protocols and requirements. There's quite a bit available in public sources from courts and various other parties and things that can give you a good start on any of these ones. And we've got a handout on that we'll provide to registrants after the webinar. We've got a lot of material here, so on some of this I'll be talking pretty quick and won't go over everything. So I apologize in advance for people that like it to go a little slower, but we'll try to wrap up in about the 30 minutes. Additionally, of course, we'll have this as the slide deck and everything will be available afterwards for anybody that wants to go back over things. First, what are ESI agreements? Well, ESI stands for Electronic Stored Information, and it's an agreement between the parties that govern the who, what, when, and how of what's being done with in a case. It's binding. Can be done with or without court or magistrate participation, but usually it's going to be done with an agreed order. It's called many things. It can be a ESI order, agreement. It can be part of a Rule 26 order, a trial order, protocol, requirement, stipulation. I'm sure there's more. And this can take many forms to a signed agreement, case management plan, scheduling orders, stipulation, etc. Lots of flexibility. Why are they increasingly important? Mainly because the cases are getting bigger, and electronic discovery and document management matters are coming to the fore, being important in more and more cases that one might see, particularly if you're doing any amount of complex litigation. Second point is they're a natural outcome of the Rule 26 conference. And often what's done in that conference is recorded in an ESI agreement. Many courts increasingly have standing orders or court practices by court or judge, and sometimes these are by practice area, that in areas where there's a particular amount of complex litigation, such as patent. Judges and magistrates are increasingly knowledgeable and expected. So years ago, maybe this, ESI, this could be ignored more now that the judges are getting involved and want to see the parties work this out. Another reason that I think these are important is that anything that one agrees to or signs early on in the case here, courts are very unlikely to bail somebody out from a bad agreement. So we've seen sometimes litigators that aren't that versed in ESI make just bad agreements that they didn't really understand what was being asked of them in these early on in the case, thinking that get to it later, and then sometimes this can involve a lot of additional costs and disappointed expectations as to what you thought. And at the end of the day, the most important thing there, even beyond the cost, is that not getting a good ESI agreement, or particularly doing a bad agreement, means that you just are not able to get the evidence into your case that you need. You're not able to get it through discovery and get it admitted, and that can impair your case outcomes. So good stuff to know. What are the underlying legal requirements of these ESI agreements? Well, there's nothing specific in the Federal Rules of Civil Procedure or state laws requiring this. Of course, we don't know all the state laws, but any that I've ever seen. Often it is in standing orders, court form protocols or guidelines. Where it comes from is it's a suggestion, or a strong suggestion, out of the meet and confer requirements under Federal Rules of Civil Procedure 26F, and that requires that the parties must meet and confer 21 days before the scheduling conference or scheduling order is due, and that the scheduling conference must occur. Presently it's 120 days, but it's soon to be changed to 90 days under the new amendments to the Federal Rules of Civil Procedure effective beginning December. Under Federal Civil Procedure 26, there's a number of requirements that at least must be discussed in the meet and confer, such as ESI preservation, form of production, proposed discovery plan, and a number of other matters. And there's a requirement of a written report to the court outlining the plan. And these meet and confer requirements often lead into the ESI agreement or order. So there's a number of things that can be included in those, and from the rest of this webinar here, we'll just go through these specifically. First is dealing with preservation and litigation holds. The ESI agreements will sometimes specify what has been done for preservation, and 26F includes a requirement that these be addressed. From the practical point of view, narrowing the scope of preservation can really reduce time and cost, and this can be achieved through a number of ways, including limiting the subject matter of what's being preserved, specifying time frames, identifying non-relevant or duplicative data sources or data that's not reasonably accessible, and we'll talk a little bit more about that in a later slide. Hold status may be addressed. Litigation holds are, of course, required, and may address when hold was issued, who received it, the subject matters, and then a number of other issues regarding preservation, including time-sensitive sources, metadata preservation, employee changes, updates, etc. And there's a recent litigation in these areas as to what extent any of this can be or must be disclosed, and to what extent these matters are attorney-client privilege or can or should be disclosed. So that can be addressed, and if it determined that they are disclosed, they can be in an ESI agreement. Another point that can be included is collection methodologies, and the ESI agreement may address what are acceptable collection approaches. The new Federal Rules of Civil Procedure that are just coming into effect include explicitly making discovery proportional. Now, in a sense, that was many would say that was in there before implicitly, and heard many judges say that they were always doing that. But to the extent that wasn't clear, and it's now in the rules, and there's certainly an emphasis on it. And also, interestingly, there was the old language in the rule that said that what was discoverable was any information that was reasonably calculated to lead to discoverable information. So the idea that responsive would be a little bit broader, what would need to come back, that's been removed. So I think now the fact that something might lead to evidence that would be introduced is no longer a key concept in discovery, and proportionality is the new rule. When doing the collections, there's two main approaches on that, directed and imaged. An image collection is when someone goes in and does a bit-by-bit forensic copy of custodian drives. Custodians being the people that hold the discoverable electronic stored information. This replicates all data, including deleted files, fragments, slack space, and allocated space in the drive. This is the safest approach to this, but this can be overkill. There's variations of this where the slack space and unallocated space isn't collected, but everything else. The other approach is what's known as a directed collection. This is more cost-effective, and it targets sources on drives likely to result in discoverable ESI, and that usually includes common document folders, any emails, certain file types, and this will be under a collection protocol. These can be, particularly in the directed collection, this can sometimes be specified in an ESI order agreement. Another important point is who collects. Is it the company IT department versus an outside vendor, eDiscovery expert or forensic expert, versus the individual custodians self-collecting? Issues around those, particularly on custodian collection, and that can be explored in the Rule 26 conference as to how and why these things were collected, and can be memorialized in the agreement as well. A bit about custodians. As mentioned, the custodian is a person who possesses or controls a discoverable ESI. The ESI agreements and orders or other pretrial agreements and scheduling order can tie down who are the custodians in a case, and local rules may limit that as well. Once the custodians are identified, any devices they have are discoverable, and this includes any number of computers and phones, and may involve social media collection depending on the case. Another issue is how to deal with shared drives, databases, and other sources that are not specifically tied to one custodian. A number of ways of dealing with those that can be done in general collection and also be in ESI orders. There are major cost implications of custodian and data sources. Who and what's being collected has a major impact on how much data is being reviewed, and this can be the single biggest practical way of limiting cost in eDiscovery is to limit how much data is being collected in the first place, and must be dealt with for review. Another important issue in collection that can be addressed in ESI orders are culling and deduplication. This is most important when there's been a broad collection, forensic, but comes up in commonly with email when you get various email stores collected, and you can have duplicate emails between different custodians or within custodians. There are a number of ways to cull down the data after it's been collected. Date limitations for what dates should be collected. File types, only certain file types will be collected. Also, deduplication. This is where one goes in and removes emails or other files that are electronically identified as being exact duplicates based on an MD5 hash. There's two main approaches here. One is horizontal deduplication that goes across custodians in the case, and the other one is vertical deduplication, where duplicate emails are only removed within or other files within the custodian collection. vertical dedupe maintains the associations between custodians, so you know what email each custodian has, where horizontal does not without special logging. A key point in determining what data should be collected is mapping out data sources. And here's an example of the database for doing a data mapping, and it will go in and identify the custodians and then identify all separate locations of ESI that a custodian has control of, and get the size and roll that up into seeing what one is dealing with particular custodians. This can also log in special data sources such as shared databases, accounting systems, specific software that is particular to a litigant. An important issue on collection and discovery in general is identifying ESI that's not reasonably accessible. Federal Rule Civil Procedure 26 provides that the parties are not obligated to produce ESI that's not reasonably accessible, and that's really presumed to be non-proportional, that the benefit of getting to this non-reasonably accessible data is not outweighed by there's not enough important information there to outweigh the cost of getting it. This is a facts and circumstances determination, determining on current technology, the case, the size of the case, the type of the data, whether the data is accessible otherwise, probably. So there aren't any hard and fast rules here. Most accessible generally is going to be active online data such as email accounts, computer hard drives, and computers in use, portable devices, easily accessible cloud storage. Offline and nearline storage and other archives may be reasonably accessible or not, just depending on the circumstances. Less accessible, generally going to be backup tapes, fragmented data, system files, temporary files, that sort of thing. The court can determine that ESI that's not reasonably accessible can still be produced with some cost shifting or cost sharing. Next thing that can be addressed in ESI agreements are review procedures. There's three main approaches that are used in cases. The first would be a linear review, and this was the way law started out, to where somebody would have eyes on every document in the case and determine responsiveness, privilege, and issue coding. That has not very cost effective with a larger document collection, so that breaks down to where that can't be done when the documents just get too big and other approaches are taken. Probably the most common one out there is for the larger cases is keyword search, and specifically crafted keywords, usually Boolean or other identifiers, but sometimes other technology such as concept search, to identify responsive and privileged emails, and a production will be done off of that. These can be tested and refined to make sure that the false positive and false negative rate is as low as it can be. And then the third approach is technology-assisted review, where the computers help make the problem of all the ESI, and the computers help solve it. This is also known as a TAR, assisted review, predictive coding, a number of different names. And there's different processes in use by different software developers on this, but generally involves a manual review of a seed set of documents, and this is used to train the computer to predictively code through an algorithm that will code the remaining document sets. And then there's a review control set that evaluates the results and statistics that show how well this worked. With keyword search, as mentioned, that's most commonly used. There's a number of approaches that can be used on keywords between the parties. One is that there can be agreed keywords, and this is often done, they can have a big implication on how much is being reviewed and produced, and these will often be included in an ESI agreement or in a separate agreement having to do with the agreed keywords. There can be, and then sometimes there will be, it can be that keyword search will be used to make clear in the ESI agreement that there has not been a linear review, but be left to the parties to determine their own keyword search based on review of the interrogatories, request for production, and other information about the case. These can or may not be disclosed to the other party if they're not under an agreement. Then keyword searches can involve testing protocols too. So keyword searches just used blindly can lead to not a very good error rate, but if tested, they can often be refined and give very, very good results. Here's an example out of our platform on doing keyword searches, and there's a number of different options. Often these, done on a basis with Boolean searches, but they can be expanded in various ways. A concept search here that brings in group documents around an idea or concept, and there's a number of other search options and things that can be done to make these more specific. Here's an example of a report for technology-assisted review or predictive coding out of our system, and you'd see similar things with other review platforms. An issue with predictive coding that is it often comes up now is just to the degree of transparency of the predictive coding. Predictive coding or technology-assisted review in general can be a bit of a black box, or a lot of it a black box. So the question is, how much of how this was done is being disclosed on the really key aspects of what's being produced. And there's a number of things that can be disclosed, including the actual specific algorithm used. Some providers disclose the algorithm, other ones treat as proprietary, and it's certainly something that is a fair question to ask. What was the actual seed set and contents? How was the seed set chosen? The control set size. There's a statistic called an F-score, or sometimes there's multiple F-scores that give an indication of precision and recall, or false and false positives and false negatives in the set, sometimes blended, sometimes separate, and those can all be reported out, and then with that you'll get a better idea of what actually was done here. But in general, with any kind of computer algorithm, it can be garbage in, garbage out. So you definitely want to understand what went into this to appreciate what's being produced. Let me move on now to forms of production. This is often a real meat and potatoes of the details of ESI orders, and gets into, and we'll do a bit of a dive into the specifics of this. First, an overview of what's in the Federal Civil Procedure on this. It's not really that specific in the sense that it gives a procedure, so it doesn't say exactly how things are going to be produced. So the way the Federal Civil Procedure 34B works is if there's no agreement between the parties, then the obligation is to produce in a form that's reasonably usable, and that means a native file, and however the custodian is working with it, Word, Excel, etc. This is not generally done because of issues of difficulty. You can't bait stamp on the page level, and it's difficult to control redaction and privilege control without getting into some other format. Continuing with 34B, if there's a specific request and no objection, then the receiving party, the producing party, has to is bound by that request. So if you receive a request in a specific form, you need to respond, or you'll be bound by it after a while. If there's a specific request with objection, then the producing party can propose their own form. So this whole procedure here, suggests that there should be agreement, and that's typically why this will go to the ESI orders and agreements. One thing to note here is it's very common for productions to be done in an imaged or TIFF format, because many eDiscovery review tools work best to require that, and there's really nothing in the rules of civil procedure that mandate that, and it's really all by agreement or an unobjected request for this. There, some practical considerations on this. One is that is just at the beginning to understand what document review technology or software will each party be using. That principally drives how the form of production, and there's various different approaches. So understanding that early on makes this a lot easier to work through these things. If somebody's using a dedicated litigation document review application, then they often will work, or many of them require a certain type of input or work best with a certain type of input, and particularly many of the older ones require that things be in TIFF format. So you'll see a lot of TIFF files being done because of that. Then you'll see some people dealing with smaller document sets that will do the review directly in Outlook or in just on their local computer, and they'll often want things converted into a PDF for the review without anything else. And that can work, with a small set. Although when people get into very large document sets, that usually becomes too cumbersome to be able to do the review in a reasonable period of time at a reasonable cost. Of the different production types, there are the main ways one can produce would be in native as a PDF or as a TIFF text with load file, and certain systems can produce some or all of those. With our system at Lexbe, just as an example, we do what we call blended production, which can provide native PDF and TIFF text, and then you can provide to the other side whatever they need on that, and that's a way of lessening the need for back and forth on this. And we'll give a little bit of detail of what actually can be produced here. One thing to say is the natives. Some people that's changed over time. If you're doing a PDF or TIFF production, the question is, are the natives going to be produced? Counsel take different approaches on this. Some do this as little as possible. Some of them are doing more regularly. Some of them will do it with only for Excel files, because those don't convert into TIFF or PDF that well. Some will do in general. So there can be a variety of approaches of how people deal with this. A key part of productions that must go into litigation review things is a load file, and this is a text or database file that allows association of metadata, and if there's been TIFF, the individual page associations are tied back into documents in the load file, and a bunch of extracted metadata can be included in that load file and associated back with documents. For people that are working with litigation databases that are not bringing documents in on a native basis, you have to have the load files with that. There are several common types in use. One's called a DAT, another one's called a DII. We use an Excel load file for Lexbe, although we can import all the other ones. And these will allow the association of the documents and are needed as part of the load. Give a little bit detail on how these look. These will include all the extracted metadata, and you can see, for example, have a metadata from an email here is parsed out and makes it into the load file here in our Excel format. Then here's an example of that same load file in a DAT, which is the native concordance file type, and you can see it. There's delimiters, special characters that allow field separation that tie it back in, so it's hard to look at, but the data is there all the same. Then here's another common one that's DII, that's from a summation native format, and they use field tokens for identification. Again, the same data that was in the Excel and the DAT file. You can see what those look like. These requirements will be set forth in what this ought to look like often in these ESI orders. This overwhelming slide is a copy of the metadata fields that are requested by the Department of Justice when they're involved in litigation. This is a larger list than you'll see standard for many cases, and there's not really a standardized form of this, and it'll really vary by what various courts requires or what various parties are looking for. And this is a pretty expansive list, but this is all the variety of data that can be extracted out of metadata and included in a load file. Some other issues on form of production that will be detailed out in these ESI orders. Parent-child relationships and email and attachments. Standard processing will separate out the attachments from the email bodies, so there needs to be a way of rolling those back up into parent-child relationships for review. Our native version is going to be produced, as I mentioned before. There can be proprietary files. If things are converted into TIFF, one of the disadvantages of TIFF is it's a black and white format, so it loses all the color attributes of files, which can be very important, including highlighting and things like that. And how will color documents be handled? A number of different ways of dealing with that with diff productions. Deduplication, if the productions will be staged or rolling or just a one-time production. Specifics of files and load types, protective orders, AEO documents, although that's usually done in separate agreements. Another important point that can be addressed in these ESI orders are privilege logging. Federal Rules of Civil Procedure require specific privilege logging and as interpreted by the courts, and this can be increasingly burdensome when you have very large document sets, and there's some knotty issues of how to deal with email threads that aren't very clear under the case law. So an ESI agreement sometimes will define or narrow the privilege logging requirements, and this can be very helpful in larger cases. And things that could be addressed are, schedule of log delivery. Absent some schedule, there may be a requirement to log and deliver pretty quickly under a use it or lose it approach on logging for privilege retention with some courts. Limiting the data logging, such as stopping it once litigation commences, or carving out certain attorneys from not having to log, such as litigation counsel brought in. There can be, you can address automated creation of document management software from metadata, email logging by thread group. A more aggressive approach on limiting is categorical logs. This has been pioneered in New York and can be done elsewhere, where areas of privilege to be done by category and dealt with by that rather than dealing with individual records. Here's an example of automated privilege logging in our platform where you can see metadata is being pulled out of emails and then fielded into the system, and then that goes in to generate an automatic privilege log, and that can be very helpful on speeding logging along. Another important privilege issue is what's known as a clawback agreement. This is authorized in Federal Rules of Civil Procedure and Federal Rules of Evidence, and the idea is that if there's inadvertent disclosure and you have a clawback agreement, that the holder doesn't automatically waive privilege, and have taken reasonable steps to identify and pull the information back in that the privilege isn't waived. This is no panacea, of course, as the horse has already left the barn, and sometimes the privilege information can be developed in other manners once it's known. So this is a fallback rather than a principal area of protecting privilege. But these will be detailed often in the ESI agreement. Last point I want to make here is that some eDiscovery agreements and courts will encourage appointment of a eDiscovery liaison, and this will be somebody designated to deal with ESI issues, and this will be an eDiscovery expert or technical consultant that can either be with the law firm or an outside vendor or with the litigant itself, and they're a point person on communications with parties over eDiscovery matters, and particularly dealing with technical exchanges and matters. And they may attend the meet and confer meetings and otherwise assist on a process basis with dealing with this. So with this will be our last slide. I'll turn things back over to Christian, but first I wanted to thank everybody. If you have any questions about this, please feel free to give me a call or email at gene@lexbe.com, and we really appreciate hearing your comments about this specifically or anything else you'd like to see in this webinar program. Back to you, Christian.
Thank you, Gene. That was a great presentation and an interesting topic. I hope that everybody else enjoyed the webinar the way that I did. We'll be making everything available on demand after this webinar, just as we discussed on the front end. If you have any questions or comments about the webinar or suggestions for future topics, please contact us, webinars@lexbe.com, or you can call us at the number that you see listed there, or email sales@lexbe.com for a consultation or demo of the software. Thanks.